Welcome everybody. Welcome to Resolving Financial Abuse Issues, Two Roads Diverged, Credit, Debt and Consumer Law or Family Law or both, your questions answered. This is a webinar presented by Redfern Legal Centre. My name's Nick Manning and I coordinate the Community Workers Training Program here at Redfern Legal Centre. I'd like to acknowledge the Gadigal people of the Eora Nation, who are the traditional custodians of the land that Redfern Legal Centre normally works from. I'd also like to acknowledge the Darug people, the custodians of the land that I'm working from today. And I'd like to pay respect to elders past, present and emerging, and extend that respect to other Indigenous Australians who are present. Jasmine and Maria, would you like to introduce yourselves?
Hi everyone, my name's Jasmine Optum. I'm a credit, debt and consumer law solicitor in our Financial Abuse Service New South Wales at Redfern Legal Centre. I'd also like to acknowledge that I'm joining today from Camaragal land and pay my respects to traditional custodians.
Good morning everyone. My name is Maria Monasteriotis. I'm an accredited family law specialist with the Redfern Legal Centre. And it's wonderful to have you all here this morning in the hope that we can connect on a topic that will assist our clients. I also would like to acknowledge the custodians of the land that I'm working on from today, which is the Darug people.
So what we'll do today is spend the first 15 minutes or so just running through what our service is, the areas of law that we advise on, and a brief overview of some of the remedies that we can achieve for our clients using either family law or credit, debt and consumer law or both. But what we'd really like to do is use most of the time today for a bit of a Q&A. So please post any questions you have in the chat feature and we'll try to get to them all later this morning. We've also got a lot of questions that have been pre-submitted, so thank you for those. In terms of a bit of housekeeping, there are a lot of resources that are available on our website. So everything that we refer to today will be available and there is a link to that page on our website, which you'll see later on in the presentation. And today's webinar is being recorded, so everyone who's registered to attend will receive a link to the recording. So without further ado, we'll dive into what our Financial Abuse Service New South Wales actually is. So we are a specialised statewide service that sits within Redfern Legal Centre, and we offer free confidential legal advice to people in New South Wales who have experienced financial abuse in an intimate partner relationship. I should say that we also have clients who are no longer in New South Wales, who might have moved interstate for safety reasons or otherwise. But if their legal issues occurred in New South Wales, then we will still give them advice. We also offer representation in eligible cases. And obviously with Sydney, Greater Sydney being in lockdown at the moment, we are very well experienced in giving advice over the phone, and we also offer Zoom and video calls if our clients would like those. All of the lawyers who work in our service are trauma informed. That's a very important part of our service delivery. So we understand the safety risks and the complexities of abusive relationships and can help our clients navigate those. We are lucky enough to have Maria in our service. So Maria joined us last year offering family law advice, which means that we can now operate with what we call a co-advice model. So when a client first contacts our service, they speak to our legal support officer who will triage that client's needs and what legal issues they're facing. So depending on what those needs are, we'll then offer tailored appointments with either a family lawyer or a credit and debt lawyer, or in many cases, an appointment where both a family lawyer and a credit and debt lawyer will both give advice in the same call. So this allows us to bring together experts in different areas of law to provide holistic advice. and brainstorm the best pathways for resolving the legal problem. We recognise that many clients who have experienced financial abuse might be dealing with debt collectors or being chased by creditors for outstanding debts, but there might also be an avenue in family law to resolve those debts. So we are very open to considering the different pathways and making sure that our clients get all of the advice they need. I should note that obviously there is a huge need for family law advice, particularly among clients who have experienced financial abuse and other forms of family violence. So we do prioritise people who are not currently represented by a family lawyer and who aren't eligible for other family law services, for example, legal aid. These are some of the areas we advise on. We often have clients asking us what financial abuse law is, and the answer is there is no area of law neatly called financial abuse. We will advise on the issues that are affecting our clients across all of these different areas of law and some others as well. So the areas that we typically give the most advice on or see the most need in are consumer credit and consumer law. So your personal loans, credit cards, car loans, complaints about credit providers giving unsuitable loans or other forms of credit. We also give a lot of advice around debt recovery, local court processes, bankruptcy, financial hardship, and of course, family law financial matters, which Maria will talk through. We also recognise that the majority of our clients have non-legal needs as well, and in the interests of offering holistic advice and support, we provide tailored referrals for crisis accommodation, financial support for clients who are in acute financial hardship, safety planning and domestic violence casework support, as well as psychological counselling and financial counselling and other financial capacity building programs.
So I'm going to talk to you about financial abuse and effectively what that entails. Financial abuse is effectively abuse that occurs between intimate partner relationships. So in circumstances where parties are married or in a de facto relationship, or in any type of intimate partner relationship. Now, it's basically a common and an ongoing abuse of a person's finances. So effectively controlling a person through their finances. And that can be a number of there can be a number of examples of that. That can include things such as controlling the use of a person's money in their account. It can include refusing to contribute to joint debts. It can include withdrawing money from their bank accounts, controlling their income, transferring property into another person's name. There's a whole number of factors that can basically constitute financial abuse. It can also include things such as being forced to sign documents and take out loans, fraudulently opening up accounts in another person's name, taking control of finances. So usually financial abuse can occur in circumstances where there is also where there is also other types of family violence. But it's important to note that financial abuse is a form of family violence, and it's defined that way in the Family Law Act. It's included as part of the definition in the Family Law Act. There are a number of remedies in family law to be able to address financial abuse. It's important to note that the family law remedies are limited because the Family Law Act defines family violence as including violent, threatening or other behaviour, and that does include financial abuse, which controls a member of the person's family or causes the family member to be fearful. The avenues that we have available to assist a person in family law when they've experienced financial abuse are property settlements, spousal maintenance, and that can include urgent applications for spousal maintenance, interim applications for spousal maintenance. That would be an application for spousal maintenance where it would be a temporary order until the person's property settlement has been resolved, or a final order for spousal maintenance. Child support for children under the age of 18, as well as for children over the age of 18. And it's important to note that child support can also be either through the child support agency and in some instances seeking a change of an assessment through the family courts. We can also seek orders to set aside existing property orders that have been made by the family court, particularly in circumstances where there's been financial abuse, and in particular where a person has failed to disclose an asset. So fraudulent behaviour is a ground to set aside an order under the Family Law Act. The other areas that we can assist in are applications for exclusive occupation of the home, particularly in circumstances of family violence and financial abuse. An application for exclusive occupation of the home assists a person in obtaining accommodation that is safe and requires their partner to move out of the home. I think that's it from a family law perspective at this stage.
Thanks, Maria. So I'll just run through a few remedies available in credit, debt and consumer law in circumstances where a client has experienced financial abuse. And I wanted to point out for anyone who's thinking, well, this is going really quickly, can we take a step back and look at financial abuse itself? We would really encourage you to have a look at our webinars from last year. There are 2 other webinars in this series which are available on our website at that link that you'll be able to see later on, where we step through how you identify financial abuse, some tips for assisting someone who might be a client or a patient or even a friend who's experienced financial abuse, and then a deep dive into ways to resolve financial abuse legal issues through credit, debt and consumer law. So this is really just an overview to situate the conversation that we'll be having about the interplay between family law and credit, debt and consumer law. So some of the pathways that we might advise and assist a client to take if they've experienced financial abuse and have debts outstanding as a result of that might be applying for financial hardship assistance, and all of the financial counsellors joining us today would be very familiar with seeking waivers of debts or payment plans. We very often will assist clients to make consumer complaints against a financial institution if our advice is that that institution has breached the consumer credit law or relevant industry guidelines and codes of practice, such as the Banking Code of Practice. There are also external dispute resolution schemes that will receive complaints and help mediate and resolve complaints against financial service providers, including the Australian Financial Complaints Authority, or AFCA, and there are other industry ombudsmen for particular industries. We also assist clients to request withdrawals of fines or what we call write-offs or waivers of fines. So there are different avenues depending on which state you're in as to whether there is a particular family violence scheme available or other mechanisms for requesting the withdrawal of fines. And in the financial abuse space, we're talking specifically about instances where someone's partner has actually incurred fines, might be traffic fines, parking fines, in their name by driving a car that was registered in their name. We also advise on debt recovery proceedings, typically in New South Wales, for example, through the Small Claims Division or the General Division of the local court. And that might be debt recovery by our client trying to recover a debt owed to them by their ex-partner or another person, or it might be our client defending proceedings brought by a debt collector or creditor.
Jasmine, just to jump in with the question, Sana's asked if we assist people on temporary or bridging visas.
Yes, so there are no eligibility criteria for our service that are connected to your immigration or visa status. As I said earlier on, our service is really designed to assist people who have experienced financial abuse in intimate partner relationships. So some of the times that we will refer a client out is if they have experienced financial abuse but perpetrated by say a child in the instance of elder abuse, or perpetrated by a family member or an acquaintance, or someone who's not their intimate partner.
And
but absolutely no criteria related to residency status.
And Heather asks if there's a means test.
No, there is no means test for our service. That's a very conscious decision because we understand that somebody's income or their assets and income on paper may not reflect their access to finances, particularly where they've experienced financial abuse.
And Grace asks if there's a dollar limit that we'd assist with, as in the amount of unpaid fines, for example.
There's no limit in terms of the amount of fines or the amount of debt that we would assist with. Obviously, the dollar figure may determine the jurisdiction or the avenue that we need to take, particularly when it comes to debt recovery, but we will advise on that. And we do have networks of pro bono partners and barristers prepared to act pro bono as well. So I would say no amount of fines, no amount of debt is too big to consider contacting us.
I might just say one more thing about questions, and we welcome questions as we go. If you find that you're writing a paragraph or two rather than a sentence, as a few people have, it's probably beyond the scope of the webinar, and it may be that that's a real case where a client needs advice. So apologies to those with longer questions that we won't be able to necessarily deal with. Thanks, Jasmine.
Thanks, Nick. And just on that point, if there are financial counsellors listening, I know there's quite a few of you who have registered. You might be coming up against some of these issues in your daily work with clients, and you might be wondering about the best strategy for resolving an issue, or just want to, I guess, phone a friend and brainstorm a matter. We do very much invite you to do that. You can call us on our phone line that you'll see later on in these slides, and have a chat to us about the issue that you're dealing with and your client, and we're very happy to give kind of informal advice or suggest that you actually refer the client to us if we think that's appropriate.
Can I also say that that also applies to any family law questions that you may have as well? So I'm more than happy to answer those for you. Just feel free to contact me through the Redfern Legal Centre. Thanks,
Maria. So I won't spend too much longer on this slide, but hopefully you've had a chance to look at the huge range of options available. There are some creative options that we often don't think about immediately when we're dealing with debts or I guess credit issues. And what's important to remember here is that there are many options available beyond your standard payment plan or advising someone to consider bankruptcy. Even if there's a huge amount of debt, a client might come in with over $100,000 worth of debt, and we will be able to work with them and get that down to zero or close to zero, or find other avenues. So this is a non-exhaustive list of some of the remedies we might be able to achieve for clients. So the best way to contact us, it's really up to you. We have a dedicated phone line, which is answered by our legal support officer. So you can know, and our clients know, that anytime they call us on that number, they will speak to the same person. That's a very big part of our trauma-informed practice. So that phone line at the moment is open from 9 a.m. till 1 p.m. Monday to Thursday, but you can leave a voicemail outside those times. You're also very welcome to email us at that email address, so FALS for Financial Abuse Legal Service, intake@rlc.org.au. or we have an online inquiry form which you can complete on behalf of a client, or a client can complete themselves, and our legal support officer will contact that person at a safe time and through a safe contact method. I touched on this before, but we don't assist with instances of elder abuse or financial abuse outside of intimate partner relationships. So the best referral pathway in those cases will usually be the Seniors' Rights Service or the National Debt Helpline. We also don't advise on credit, debt and consumer law problems that are not connected to financial abuse. So in that case, you'd be contacting your local community legal centre or legal aid. And again, family law issues, if there are no interconnected credit and debt issues or financial abuse, because we do have limited family law capacity, we'd encourage you to contact your local community legal centre or legal aid.
Thanks, Jasmine. Can I start by asking you to just cover off on the situation interstate? We have a lot of viewers today from, I think, all states and territories, even some that aren't in lockdown. Hello, Perth. So we've had a few questions about interstate, and I guess that breaks into the question about whether the service is for clients, but also some people have asked whether as workers they can contact yourselves from interstate, even though you can't assist their clients.
That's a great question, and we have actually had queries from financial counsellors and lawyers in other states before. We recognise that not every state has a specialised financial abuse service, so you're very welcome to give us a call to the extent that we're dealing with legislation that is Commonwealth legislation and not state specific. Very happy to help. And there are also services and some community legal centres in different states which do quite a lot of financial abuse work. So if you're outside of New South Wales and there's no nexus to New South Wales in terms of the debts or the issues that your client is dealing with, then feel free to give us a call. We might be able to point you towards an appropriate service in your state, or you can call the National Debt Helpline or contact the Community Legal Centre peak body in your state for referrals.
Thank you. And we've got some questions about contacting us. You'll see on the current slide at the bottom, there's a link to a page on our website. If you go to that page now or at any time, you'll find a whole host of resources that Jasmine and Maria and their peers, their colleagues have put together, and our contact details are there as well. So I encourage you to go there. Also on that page are the recordings of the 2 webinars from last year, which Jasmine mentioned, and the recording of today's webinar will be on that page. And we have a couple more webinars coming up. So that's your central page for everything concerning financial abuse legal education at Redfern Legal Centre. And the slides we'll put up there too a bit later today. Thanks, James, for reminding me about that. I might just go to we've got quite a few specific questions, but I might go to a more general question from Linda. And I know we talked about this quite a bit in the webinars last year, but briefly, do most of the banks and debt collectors, and I guess also other financial agencies, have DV and financial abuse policies or specialist sections in their organisations?
That's a great question. The answer is yes, particularly the major banks. Where we see a bit more of a lag in terms of domestic violence and financial abuse policies is actually in the mid-tier lenders and smaller lenders and mortgage brokers. But the majority of banks and financial institutions that you would be dealing with do have domestic violence and sometimes specific financial abuse policies, and typically also have teams that sit within either their customer vulnerability team or their financial hardship team that are specially trained to work with customers who have experienced family violence. So it's a good idea when you're reaching out to them to ask for a case manager or staff member who has that training to be allocated to the matter. There are also a number of industry-wide guidelines. So the Australian Banking Association has just this year updated their industry guidelines on preventing and responding to financial abuse and preventing and responding to domestic violence. And those guidelines are both available on the resources page that Nick was just talking about.
Thanks, Jasmine. A couple of questions for you, Maria. Firstly, what are the ways to address partners claiming, quote, loans from parents that they say have to be paid back and come out of the settlement funds jointly, even if the money was given at the beginning of the relationship?
Thank you. When a court deals with a property settlement, they will make a list of all assets and liabilities, and that includes liabilities that are owed to third parties, including parents or other family members. It's important to ascertain whether there is any evidence pertaining to the loan. So some of the things that, that a lawyer would need to check would be whether there is any loan documentation, whether there's bank statements showing the transfer of the monies from one person to the other, and in fact, what was the money used for. Also, the timing of the loan is extremely important in that depending on when the property settlement occurs, depending on when the matter is heard by a court, it may be that the loan can no longer be recovered by the parents. And so that will be a relevant consideration by the court as to whether they treat it as a loan. So generally speaking, it's the relevant question is whether there's any evidence that there's a loan and whether the money has been contributed. If the evidence is in the positive, that is that there is evidence that there is a loan that exists and it can be recovered, and it was used for the benefit of the family or the couple, then in those instances, the court will include it in the pool of assets to be divided. It will reduce the asset pool. However, if it can't be shown that it is a loan, then it may be treated as a contribution by the court, and then that will be relevant when dividing the assets. So it will be treated as a contribution made by the party to whom the parents lent the money to.
Okay, thanks. And another question, Maria. Are there any consequences if your partner has hidden bank accounts that he used for gambling large sums of money when it comes to spousal maintenance?
The answer to that question in terms of consequences is no. The court, in order to make an order for spousal maintenance, needs to be two things that you need to prove. One, that a person is in financial need, so the person applying for spousal maintenance has financial need, and two, the other person has capacity to pay. And there is an obligation on the person seeking spousal maintenance to show that the other person has capacity to pay. They can do a number of things by issuing subpoenas to various financial institutions for their bank statements. They can issue subpoenas to an employer. But if there are accounts that you're not aware of, it's very difficult to rely on those accounts. So unfortunately, for a spousal maintenance, there are no consequences if one of the problems is gambling.
Okay.
That will differ, for example, if it's a property settlement, and there are consequences because that will be treated as wastage. So it's important to note, if there has been gambling, that it will be relevant in a property settlement, but not necessarily in a spousal maintenance application.
Okay, and a couple of live questions. They might be for you, Maria, I'm not sure. What support is available regarding joint mortgages where the partner stops the payments?
So from a family law perspective, the first thing is that an application can be made for spousal maintenance to seek payment of that mortgage. payment. So that's one of the avenues available to you. The other avenue that's available to a client who's experiencing difficulty in terms of mortgage payments is to consider whether they want to seek an interim property settlement order, and whether that may include the sale of a home. That may be something that they want to do. It may be difficult, particularly in circumstances if they've got no other sources of accommodation. It's important to note that if you do seek the sale of a property and there is equity in that property, you can seek an order for an interim distribution of funds so that that client can have money to live off until the property settlement is dealt with. Jasmine, would you like to take the other?
Sure, I'll just add that we recognise that family law matters, particularly property settlements, can take quite a while to get resolved. So what we often do, and that's a great question and comes up quite frequently in our co-advice appointments, is while we might be giving the client advice about how to resolve the property settlement in the longer term, we might also be giving the client advice in the short term about how to have that conversation with the lender and how to seek some kind of financial hardship assistance from the bank or the lender to make sure that the client isn't going to be listed for default and that the bank isn't going to foreclose on the mortgage while this is all going on. There are a lot of options available, including a moratorium on interest and fees or on repayments altogether, to allow the client time to sort out their financial affairs and property settlement. And I should also note that there is no requirement for a borrower to get their co-borrower's consent in order to seek a financial hardship arrangement. So their co-borrower, if that's their partner, for example, will be notified if a hardship arrangement is entered into, but they don't need to get their consent to contact the bank and request a hold on repayments. And the bank actually has discretion who to pursue for that debt. So if both parties are jointly and severally liable, the bank might agree in the circumstances not to take action against our client and to only pursue their ex-partner for that debt. So it's important to think about both the short term and long term and keep the bank and the lender at bay while you're resolving the property settlement.
I've also sent copies of an application for a property settlement to the bank, or an application for spousal maintenance or interim property orders. So I've kept banks informed in relation to the current status of proceedings, and quite often they're prepared to hold off until an interim order is made at the very least. I should note that the delay in relation to property settlements at the moment with the family courts can be anywhere, nationally it can range anywhere from a year and a half to 4 years. In Sydney, it's at the moment, unfortunately, about 4 years to get an actual final trial date.
Okay, Heather's got a question. What happens when there's a property settlement and the property goes to the wife and the husband decides to go bankrupt on unsecured debts? Is the property at risk? Now she adds potential abuse as settlement was a private agreement.
So if it was a private, so there are a couple of things. The first thing is that the only way that you can get a property settlement that's enforceable is if orders are made either by the family court or federal circuit court, either by consent or by through a hearing, and the parties have entered into a financial agreement. Handwritten agreements between parties that don't fall within that criteria are not enforceable. So that's the first thing that's important to note that. The second thing is that it will depend on the ownership of assets as to whether the bankruptcy will impact on the orders being made by the court. But if the bankruptcy was something that was not considered, it may be important to, at the time when the orders were made, it may be a ground to set the orders aside under the Family Law Act. So it's important that all liabilities are disclosed when orders are being made by the court. So when there are negotiations in any application, the financial circumstances of a person needs to be disclosed. If there are liabilities that haven't been disclosed, that would be a ground under Section 79A of the Family Law Act to set aside the orders and to seek different orders depending on what the assets are. But we would need to look at the individual circumstances of that case to ascertain whether there are avenues available.
Okay, a question for you, Jasmine. What are a woman's legal rights if her partner has coerced or forced her into taking out loans and or putting contracts in her name, such as phones or other technology, cars, etc.?
So this is one that we see come up, unfortunately, very frequently in our service. The short answer is that credit providers are expected to identify warning signs of financial abuse and satisfy themselves that the borrower is actually going to receive a substantial benefit from the loan. So if there's been coercion or fraud by their partner, and the partner has pressured the client into taking out a car loan or adding the partner's phone plan onto their telco account, things like that, they should absolutely seek legal advice, because this could give rise to a complaint that the lender has breached their obligations under the credit laws in terms of responsible lending, or it could be an unjust contract, or state-based legislation. So in New South Wales, you're looking at the Contracts Review Act. In practical terms, we are often successful in negotiating for cars to be surrendered and repossessed, or phones to be returned, and our clients released from all liability for those accounts. And we also sometimes will get a refund of any amounts our client repaid towards the loan, in recognition that they have incurred a financial liability for a car or a phone plan or a loan from which they actually received no benefit, and that they should not have been the borrower approved in the first place.
Okay, thanks. Another question for you, Maria. A very common issue with parents I work with, not me, but the person who submitted this, is the disappointment of the other parent earning cash or money in their own business to avoid paying child support. Is there an easier way to report this to child support or Centrelink or the ATO? Is action ever taken?
Yes, so there are grounds with which to seek a departure review of a child support assessment, and one of the grounds is that the taxable income of a person is not, the financial circumstances of a person is not reflected in their taxable income, and that's quite often in circumstances where a person has a business that is predominantly cash-based. So that application for review can be made. If the application for review is unsuccessful, then an appeal needs to be made through the Social Security Appeals Tribunal. And if that is unsuccessful, then an application can be made to a court to seek a variation of the child support assessment. The other thing is that it's something that's not commonly known. However, if there are proceedings on foot between parents, then that would be a ground to seek a departure order without having to go through that process through the child support agencies. So a departure order can be sought from the Family Court or Federal Circuit Court in relation to child support, and quite often you can seek an order for an adjustment on that basis. The other thing that's important to note is that the non-payment of child support or the refusal to pay child support, or minimising someone minimising their income with a view to avoiding having to pay child support, is a ground to seek a further adjustment in a client's favour in a property settlement. So that would be the basis to go to the court and say, listen, this fellow's not paying child support, or this person's not paying child support. What we need to do is seek an additional adjustment in their favour by virtue of that fact, because this parent will have the sole financial responsibility of these children in the long term.
Okay. And another for you, Maria, can an ex-partner fail to honour a property settlement agreement made during mediation?
Unless it's been, so anything that occurs during a mediation is confidential, and the reason for that is to allow parties to be able to speak freely about their property matters and try to reach an agreement and negotiate freely without any restraint. Unfortunately, if the agreement is not formalised by having orders made by consent, it is not enforceable.
Okay, and a couple more that have come in live. Grace asks, a client having financial hardship in Australia is required to pay child support for family living overseas. What are the avenues available for this client to make it more reasonable?
I would need to know a little bit more about the individual circumstances of that particular case. However, there is consideration under the assessment at the moment under the formula for existing dependent children, whether they live in Australia or overseas. But the only grounds within which to seek a departure, there are 10 grounds within which to seek a departure. And so it would be a question of whether they fit into one of those 10 grounds. The Child Support Agency, the website on the Department of Human Services child support is really good, and I would recommend that people have a look at that because the 10 grounds are actually outlined in detail there.
Okay, an interesting question here for both of you. What are some strategies for starting a discussion about financial abuse? When confronting the person abusing or withholding finances, how do we confront and motivate them for change? This is assuming they continue to be part of that person's life.
I think the first question that needs to be answered is whether it's safe to do so. I think that's an absolute priority. Assessing the safety in order to do so is really important. I think the next thing to consider is whether it can be done with a third party, and that is with the assistance of a counsellor or a therapist or a family mediator. Preferably not, when I say family mediator, I mean a mediator who's experienced in mediating family law matters, rather than someone within the family where it can get very emotional. So it would, in my view, it would be trying to address the issue with a third party who's experienced in financial abuse, has an understanding of financial abuse, and has an understanding of the ramifications, both from an emotional point of view as well as a financial point of view. Jasmine?
Yeah, from a practical perspective, absolutely safety is paramount in that situation. And I think expressing a willingness to move forward and to have a relationship where financial decision making is more equally shared and there is more disclosure can be quite different to facing the realities of what that relationship looks like. If you are at the point of moving forward in that way, there are some practical steps that can help cement some of the decisions that might be made through that mediation process that Maria is talking about. So an example would be contacting banks to request changes to the authority structure on joint accounts and making sure that those accounts require 2 signatures for withdrawals and transactions, for example, so that one person can't unilaterally make withdrawals or make those decisions, changing permissions around access to accounts so that both parties have visibility over joint finances. There are some practical ways that banks can help with that. And as I mentioned earlier, most major banks do have specialised teams that can actually work with customers on the setup and the arrangements that will work best for them.
The other thing that I would recommend is also having a safety plan that involves putting aside some money. So whilst you're in the relationship, putting aside some money so that if at all possible in an account that that the other person isn't aware of, with a view to having an escape route if necessary.
Okay, and another process question, if you like, for you, Jasmine, is what is the best way for clients to collect evidence of financial abuse?
As Maria has indicated, I think the first step in this case is always to have a safety plan in place. Any of the steps that we recommend to collect evidence of financial abuse can risk putting the victim survivor at quite serious personal risk. So I would always suggest speaking to a domestic violence support service, or at the very least calling 1-800-RESPECT. It's a free national 24/7 phone line that can do that safety planning over the phone. Once that's in place and there is a level of protection around the victim survivor, some of the obvious things are getting things in writing, particularly where a partner has admitted to owing a debt, or taken responsibility for making repayments, or acknowledged that a particular debt or loan was taken out for their benefit only. Getting all of that in writing will be very helpful for the client, either trying to recover those debts down the line, or trying to present that to a third party, say a lender or a bank, to try to negotiate their own repayment obligations, or remove their liability for that debt. It can also be helpful to have copies of bank statements and copies of loan contracts and things like that. That is less important if it's in the client's name, because they are entitled to then request copies of those documents directly from the financial institution. Where that is more important is if these bank accounts and debts and loans aren't actually in the client's name, because they will not be able to contact a financial institution and be entitled to access that information if they're not named as an account holder or as a borrower.
Sorry, Maria, just on getting things in writing, I know at the front desk of Redfern Legal Centre, where I often work, we get a lot of screenshots of text messages and social media messaging. Does all that count as in writing in the law's eyes?
Yes, so a text message is fine. We can actually use that as evidence in court, certainly from a family law perspective. From a family law perspective, particularly if there are accounts that a person is not aware of, or they find things and they think it may be important, take photos, as many photos as possible, provided that it's safe to do so, of course. Because that will actually be able to assist the lawyer in progressing the matter further, particularly in relation to knowing what questions to ask and where to look for information, particularly if there are things that are hidden. So one of the biggest problems that clients experience with financial abuse is that there are a lot of accounts that they're not aware of, assets are hidden, they're transferred to third parties, and be aware that if they are transferred to a third party, it is possible to seek an order to set aside that transaction. And even if that occurred during the course of the relationship, it's possible to set aside that transaction. So take photographs of anything that you can effectively, if at all possible, and if it's safe to do so.
And just on that question without notice from me, given that we're talking about taking photos and so forth, do either of you want to comment on the issue of technological surveillance of, hidden apps and that sort of thing that might be embedded on victim survivors' phones and so forth?
I'm not a technology expert. Jasmine, did you?
I would suggest that if a victim survivor has serious concerns about that they contact a domestic violence support service, because they have the resources available to provide safe phones that are completely clear of any apps or potential surveillance. We can also, in our appointments with clients, we often run through practical tips in terms of changing passwords and securing bank accounts and financial accounts, but a domestic violence support service will be best placed to do that as part of their safety planning and really step through all of those options.
Thank you. So a few questions about particular equity groups, perhaps. The first one for you, Maria. I'm noticing issues with ex-partners still being nominees on plans for their ex or for the children. The NDIS doesn't seem to have a clear pathway for dealing with this. Do you have any guidance or information about what to do where there are allegations of abuse, but parenting orders in place, keeping both parents as nominees for a child's plan? So I gather a nominee is, perhaps you could explain what a nominee is first.
My understanding is that a nominee is the person who actually manages the plan. Is that correct, Jasmine?
I'm not an expert in the NDIS, so I'll have to defer on this one.
What I can say to you is this, is that because it is a problem in terms of, look, I can't explain the NDIS issue, but I do have situations where a person can only claim, only one party can claim Medicare entitlements. And so those sorts of things can actually be dealt with in the parenting order. So in the parenting order, you can specify who the nominee is to be. It is a parenting issue. It can be dealt with in the parenting order. It will avoid any problems in the future. If a parent has an order for sole parental responsibility, then that themselves allows them to be the nominee. So because it gives them sole parental responsibility to deal with any major issue pertaining to a child's welfare. But you can actually put a specific issue order in a parenting order which states who is to have the children on Medicare and claim for Medicare and private health insurance, and whilst I've never seen it done, there is no doubt that an order can be sought in relation to the nominee for NDIS. I hope that helps. I'm sorry I can't give any more information about that.
Thank you, Jasmine. What support do you offer for people from CALD communities, culturally and linguistically diverse communities, or where English isn't a first language?
So the first and I guess most obvious answer is that we do offer free translators, whether that's through initial contact with our legal support officer at intake, and also obviously for all of our appointments with our lawyers. But we also focus on culturally sensitive communication. So all of our intake is done by our legal support officer, and she is our one point of contact for all of our clients when they reach out to us. And can build that rapport with clients and make sure that we're actually addressing and accommodating all of their needs. We do also make it available to our clients if they would prefer to speak to a lawyer and or a translator of the same gender. So we will make adjustments for that in our rostering and make sure that we can accommodate clients. And in terms of our clients from First Nations communities, Redfern Legal Centre does employ an Aboriginal and Torres Strait Islander legal access worker, Maureen, who is a great support for us and for our clients. And we also will sometimes recommend that clients contact Warringah Buyer, for example, if they're interested in an Aboriginal women's legal service specifically.
Thanks. And I might just ask you about the gender breakdown or eligibility, because a lot of our questioners have understandably used gendered language, but do you want to just comment on who we work with?
So we have no gender requirements for our service. A lot of people and workers in the family violence and financial abuse space can sometimes lapse into using gendered language, because statistically we know that financial abuse does impact more women than men. But having said that, our service is not at all limited to women experiencing financial abuse perpetrated by men by any means. And we have had many male clients, both in same-sex and heterosexual relationships. So there is absolutely no gendered requirement.
Okay, thanks. A question for either of you. And our questioner says, no worries if this is too obscure, but they're interested in dowry abuse and in particular, any opportunities to recover a dowry post-separation, or how are dowries treated in a property settlement?
Okay, so a dowry is treated as a contribution if it's actually been used. So if money has been received and it's actually been used for family purposes, it will be treated as a contribution. It is unfortunately not a loan, and so the court will not treat it as a liability. It is in terms of recovering it by the third party, which usually is a parent. Again, it would be, I'm not aware of any case where it has been recovered. It can be recovered legally. However, it can be treated as a contribution made by a party. And in that instance, it could be relevant to a property settlement.
Okay, thank you. I've seen the time. We've only got a couple of minutes left for questions. So I might just limit ourselves now to the questions about how our service works before we wrap up. Lisa asks or wishes to confirm, does there need to be interlocking debts and property settlement issues for our service to be able to assist?
No, so we will, as I said earlier, we will triage at the intake stage whether the client needs family law assistance or credit and debt assistance or both. So sometimes there's a need for both in one appointment. Other times we have clients seeking advice only about property settlement where they've experienced financial abuse.
Okay, deviating from what I just said, but do you envisage the changes to the family law structure will affect clients experiencing financial abuse in the future? I don't know if that's a big question.
I don't think on a practical basis it's going to change anything. It is a very large question, and for another day. There is no doubt that unfortunately, whilst we are moving in the right direction, there are a lot of difficulties experienced by people who've experienced financial abuse, and the system allows for financial abuse to continue even during the course of proceedings, and indeed to be perpetrated through the proceedings in a way that's almost systematically approved of. It's an area that is in desperate need of reform, and one that it's a very huge area. But unfortunately, I'm not confident that the changes will assist in that regard.
Okay, do you work in concert with financial counsellors? How do you ensure there's no duplication of effort regarding hardship arrangements, etc.?
We do work very closely with financial counsellors, and we often have financial counsellors attend appointments with clients if they're willing and able to do so. We will often accept a referral from a financial counsellor where they identify that there's a more complicated legal issue. We might then assist with drafting responses for the financial counsellor and the client to send to a creditor, or we might take the matter on altogether, deal with the legal issue, get a resolution for that particular debt, and then kind of hand the client back to the financial counsellor for ongoing assistance with managing other debts. We work very closely together. There is obviously some overlap in the work that we do, so we're very mindful of that. And I just wanted to address another question, which I'm thinking is probably from a financial counsellor, about getting copies of family violence policies from creditors who won't disclose their internal policies. The answer is yes, you can absolutely request a copy of their policy. I have had many creditors provide them to me on a confidential basis, only for use with that particular client's matter, but not for external sharing. If they won't agree to provide their policy and you think that's critical to resolving the issue, you might consider escalating the matter to AFCA, because AFCA will, the Australian Financial Complaints Authority, they will request a copy of any relevant internal policies from the other side. And as part of their information sharing, you would then get a copy of that unless they can prove that that is so confidential and commercial that it shouldn't be provided to you as the other party. So that's one way of getting around it.
Okay, last two questions. Is there wait time at your service once a referral's been made?
In terms of the wait time for our legal support officer to respond to inquiries and web forms and things, I would say the turnaround time is usually within a day or two, provided we can get onto the client or the referrer safely. The wait time for an appointment, depending on demand, could be up to a week or 2 weeks, but it really depends. It's difficult to say.
Okay, and final question from Megan. Are you seeing an uptick in queries during this COVID lockdown? Interestingly,
we found that at the start of lockdowns last year and this year, that our demand actually drops off a little bit for many reasons, including that people are dealing with a lot and they're homeschooling, they're working from home, and debts might drop to a little bit lower on their priority list. There are also very real safety risks for our clients who might be isolating with their partners, and their safe methods of contact might have changed. So we actually usually see a bit of a downturn in demand at the very start of lockdown, particularly because banks and lenders are usually quite open about their hardship policies. So people know that they can contact them for short-term hardship assistance or freezes. Where we see demand pick up is usually later on in lockdown, or even after everyone's come out of lockdown again, where their legal problems haven't gone away, but they're in a better space to be able to engage with them.
Yeah. I want to reiterate that safety is a big issue, and I do have clients who communicate with me via text for safety reasons, but one of the reasons why it's difficult is because when people are working from home, they cannot communicate with a lawyer safely. Quite often, their partner is not aware that they're actually communicating with a lawyer about these issues, particularly in circumstances where they haven't separated. Yeah.
Okay, thank you. Thanks for that. That was very comprehensive, very interesting. Jasmine, I think you're going to pull up the PowerPoint slides again, and we'll deal with a few final housekeeping matters here. We've got 2 more webinars this year, one in a couple of weeks, which has bookings open. You can go back to our website and book for that. And another one in September, which will open bookings for at some point during August. You can see the link at the bottom of that slide to all our legal training for community workers. So I encourage you to have a dive into what we have there, including a back catalogue of quite a lot of recorded webinars. Some of them are freely available and some of them to our paying subscribers. If you want to learn more about Redfern Legal Centre's work, we strongly encourage you to follow us on various platforms there, and you can sign up for our e-bulletin where we have small snippets about big work that we're doing in advice and law reform and education and so forth. So I really encourage you to sign up for the e-bulletin. And finally, before you go, my contact details are up there. Feel free to email me at any time if you have any questions or thoughts about community legal education. And at the end of this webinar, a short feedback form will appear. It takes about 30 seconds. We really appreciate your feedback so we can keep improving our community worker training program. So thank you, Jasmine. Thank you, Maria. That was great. Thank you to everyone all over Australia. Stay safe, and we'll see you at another webinar. Goodbye.